So let's recap what's happened in the first 3 days of the trial. We had a prayer, then the lawyers argued. We had another prayer, then the lawyers argued some more. Then we had another prayer, and there was more legal argument. At one point, the judge posed for pictures. We did pick a jury at some point, and all I can tell you is after 3 days of trial, you have heard more about what went on in the courtroom than the jurors did, who were mostly excluded from the courtroom. This all sets the stage for day 4 of the trial, Wednesday, July 15th, 1925. By the way, good morning. We begin in court, of course, with a prayer by the Reverend Dr. Charles Potter. Does that name sound familiar to you? That's right. He's one of the clergy who signed the petition submitted the day before that the judge had referred out to the local association of clergy. The petition saying, can we have some non-fundamentalists doing these opening prayers? This is the same Reverend Potter who had been invited to preach at the First Methodist Church North, and the congregants protested, and he agreed not to come, and the house preacher, Reverend Bird, resigned. That's this Reverend Potter, who opens court this Wednesday by saying, "O thou to whom all pray and for whom are many names, lift up our hearts this morning that we may seek thy truth. May we in all things uphold the ends of justice and seek that those things may be done which will most redound in honor to thy glory and to the progress of mankind toward thy truth. Amen." His prayer was about 10 minutes shorter than any other prayer. The author, Ray Ginger, commented, "Some fundamentalists would have found it less painful to yield to Clarence Darrow's argument that there should be no prayer and admit the prayer altogether." Following the prayer, defense lawyer John Neal, prosecutor Sue Hicks proceed to have more argument about whether there should be any prayer at all. Sue Hicks says, "I have sat over here and remained quiet these 3 days while the defense counsel have been constantly bringing up objections to these prayers. This constant heckling every morning should be avoided. We are trying to avoid any religious controversy, and we maintain that there is no religious controversy in this case. Their very opposition contradicts their own selves." I don't think that was one of the great moments of oratory in the trial. "They say, Your Honor, that evolution does not contradict the Bible, does not contradict Christianity. Why are they objecting to prayers if it doesn't contradict the Bible and doesn't contradict Christianity?" Whereupon Judge Ralston weighs in. "The court believes that any religious society that is worthy of the name should believe in God and believe in divine guidance. The court has no purpose by opening the court with prayer to influence anybody wrongfully, but hopes that such may influence somebody rightfully. It has been my custom at times, when there's been no minister in the court, I have called upon some good old pious man whom I knew was good, who believed in God, to open the court with prayer. I don't think it hurts anybody, and I think it may help somebody, so I overrule the objection." Okay, having finished with the prayer and the objection to prayer, we pick up with the important business of the insults of the previous day. Attorney General Tom Stewart begins by apologizing to Arthur Garfield Hayes for telling Hayes to shut up. Okay. Hayes responds by saying he's happy to accept the apology. Then he says, "Look, I hope there shall be no further reference or allusions that are disrespectful to the state from which counsel for the defense come, and there should be no references or allusions to the economic, political, social, or religious views of counsel for the defense." Fair enough. Hayes says, "There are two qualities I admire much in a man. One is that he is human, and the other is that he is courteous. The outburst yesterday proves that the Attorney General, Stewart, who told him to shut up, was human, and the apology proves that he has the courtesy of a Southern gentleman." So everybody is now lovey-dovey, right? Not so fast. John Neal says, "I am not at all satisfied with the apology of General Stewart, and he knows why. In that discourteous action yesterday, there was included another very grave discourtesy to one of my colleagues. I have given him every opportunity to apologize privately for his remark, and he has refused. And now I ask him in public to erase from the record the slurring, discourteous remark that he made in regard to another colleague of mine in this case. Tom Stewart says, when I do a thing that I feel badly about, I apologize. So long as I speak what I conceive to be the truth, I apologize to no man. Who was the other colleague of Neil's that Tom Stewart had spoken about? It was Clarence Darrow. What was the grave discourtesy, the slurring, discourteous remark that Stewart made about Darrow? He called him an agnostic. This reminds me of that moment at the 2008 Republican National Convention, when that great contemporary moral philosopher, Rudy Giuliani, belittled the Democratic nominee Barack Obama as a community organizer. More about that later. So we're finished with the prayer, we're finished with the insults, and now we get back to a really good story, the cliffhanger that Judge Ralston left us with at the conclusion of the previous day's proceedings. You may remember, Judge Ralston had been preparing a ruling on the defense motion to dismiss the indictment. He hadn't yet issued the ruling, but he had learned that the press was already reporting about it, and he was outraged. So you might remember, he appointed a 5-member committee of the press to get to the bottom of this. Now we're going to hear the report of that committee of reporters. So the story of what got reported back to Judge Ralston in court on this Wednesday begins with what happened the night before after court adjourned. Get ready for a seminar on investigative reporting. That Tuesday night, the reporters assigned by the judge to figure out the source of the leak got together and they formed a mock court. And they called before them William K. Hutchinson, the reporter who had sent out the story that outraged the judge. Hutchinson, the reporter, tells his colleagues, he says, I overheard Darrow congratulating Brian on getting the judge to deny the motion to dismiss the indictment. And Brian admitted this would be the judge's decision. So the mock court decided that Hutchinson had done no wrong. Now the chair of this little press committee, Mr. Beamish, tells Judge Ralston in court. He says, he respectfully reports, it has been ascertained that the brief bulletin to the effect that the decision would uphold the indictment was based on information that the sender of the bulletin believed to be correct and truthful. The sender did not obtain this information from Your Honor's stenographer. That would have been a breach by the stenographer. The person didn't get the information in any improper, unethical manner. There's no good ground for any further investigation, and we say that's the end of that. Why does Beamish not tell the judge what actually happened? And Judge Ralston has the same question. He says, I think the court's entitled to know how the information was had if you can furnish me that information. Now, if any of you is nutty enough to have read enough about the trial to actually know where it came from, I don't want you to say anything. But for the rest of you, normal folks, what do you think, who do you think the source of the leak was? You know, could be some citizen of Dayton. Was it a courthouse employee? Did it come from one of the lawyers? Did it come from Darrow? Did it come from Brian? For what's about to come, let me give you some play-by-play that we get from our friend, Rabbi Jerome Mark. You'll recall last week I shared with you some of the contents of Rabbi Mark's 8-page reminiscence of the trial that he wrote in 1959. 8-page reminiscence. 3 of those 8 pages were dedicated to describing what we're talking about right now. Rabbi Mark called all this the first highlight of the trial. We're in day 4, okay? When the judge said the court was entitled to know what had happened, Rabbi Mark wrote, the reporter, who had been waiting for just that sort of an opportunity, and with a wink of his eye at the press table, let go full blast. Here's what Mr. Beamish actually said in court. Upon investigation, we find that the information, the leak, came from the court, the judge. Judge Ralston exclaims, well, now wait a minute. Hadn't the mock court heard from Hutchinson the night before, or Hutchinson told them that he overheard Darrow talking to Brian, and that was that? Yes, but there was another piece to what happened Tuesday night. The author, Ray Ginger, tells us that later Tuesday night, Mr. Hutchinson, the reporter, got a phone call from somebody at the International News Service where he worked. And this somebody at the International News Service wanted to know in confidence, how did Hutchinson get his story? So Hutchinson tells this person a different story from what he told his reporter colleagues, except the person who called Hutchinson and got this other story was not from Hutchinson's employer. It was from one of his reporter friends who was doing a bit of investigating reporting himself. The caller, one of the members of this little committee appointed by the judge, had snookered Hutchinson into telling the real story. So Mr. Beamish goes on to tell the court what actually happened. And as author Ray Ginger says, the only person more astonished to hear this story than the judge was Hutchinson. The real story goes as follows. A young man had met the judge on the way to the judge's hotel. The judge had a bundle of papers under his arm. The young man asked if that was the judge's decision on the pending motion. The judge said, no, the decision is being copied by his stenographer. The young man asked the judge, will you read that decision this afternoon? The judge says, that's my intention. Young man, will you adjourn court until tomorrow? The judge says, yes, I think so. And the inference was that if the motion to quash the indictment was denied, namely the trial's going on, there would be an adjournment to pick up the trial. If the motion to quash the indictment was going to be granted, the trial would be over. It was pure deduction by the young man talking to the judge, who then sent on the story to the press. The judge says, who is that young man? And Mr. Beamish says, Mr. Hutchinson. The judge calls Hutchinson before him. Says, you shouldn't have done that. You had no right to inquire if the court would adjourn until tomorrow. He says to Hutchinson, you have anything you want to say? So what's the judge going to do? Send him to jail for this? Hutchinson says, I'd be glad to talk to you in chambers. I don't think I ought to do it right here. Mr. Beamish, on behalf of the journalism crowd, says, Hutchinson's an upright guy, thoroughly honest. He's got the approval of all his colleagues. I think what Beamish is saying to the judge is, don't be ridiculous. This is a good guy. You're running for re-election next year, Judge. He was just doing his job. You screwed up, and you don't want to piss him off. The judge says, okay, in the future, just ask me what you want to know. And Rabbi Mark wrote, I need not add that this literally brought down the house. That was the end of that. So now we get back to the other important business of the trial, namely, how did Clarence Darrow feel about being called an agnostic? Darrow rises and says, I don't want the court to think that I take any exceptions to Mr. Stewart's statement. Of course, the weather is warm. Remember, it's all about the heat. And we may all go a little further at times than we ought to, but he is perfectly justified in saying I'm an agnostic, for I am. And I don't consider it an insult, but rather a compliment to be called an agnostic. Darrow goes on to say that Stewart had called him an infidel. Darrow says, everybody is an infidel who doesn't believe in the prevailing religion. In a Mohammedan country, everybody that is not a Mohammedan is an infidel. The fact that I'm an agnostic ought not to weigh in the balance as to whether Scopes is innocent or guilty. I don't take any offense whatever in his having said I was an agnostic, although I hate to be accused of such a foolish thing as infidelity, because everybody in the world can be accused of that. The judge says, what do you say, Mr. Stewart? And Stewart says, I think we're wasting a lot of time. Who can argue with that? So the judge says, yeah, Darrow's right, cut it out. no more references to religious stuff. And he says, now I'm going to read my ruling on the motion to quash the indictment, but turning to the press, if you gentlemen want to take my picture, take it now. Really? The transcript says there's laughter in the courtroom. The judge then reads his decision on the motion to dismiss the indictment. 8 pages of court transcript. The judge talked for about 50 minutes. Naturally, the motion to dismiss the indictment was denied. The court adjourns until the afternoon. We're now halfway through day 4 of the trial. The judge calls the jury in. The judge asks, how does Mr. Scopes plead to the charges? We're 3.5 days into the trial. The defendant hasn't even entered a plea to the indictment. The defense team says he pleads not guilty. Scopes does not open his mouth. The prosecution and the defense then make their opening statements. It's nothing we haven't already heard. Dudley Field Malone, in his opening statement, is talking about William Jennings Bryan's views on things. Stewart objects. The judge asks him to keep it out. Malone says, well, I will, but I don't think Mr. Bryan is in the least sensitive about this. You get the feeling they're trying to bait William Jennings Bryan, right? And Bryan speaks up and says, sensitive? Not a bit. He said, the court can do as it pleases in carrying out its rules, but I ask no protection from the court, and when the proper time comes, I shall be able to show the gentleman that I stand today just where I did. And now there's applause in the courtroom. More back and forth between the lawyers, and then something really incredible happens for the first time in the trial. A witness got to take the witness stand. We're in day 4. Walter White was the superintendent of schools of Ray County. You may remember Walter White had called William Jennings Bryan the world's greatest man and first citizen. And White was a Republican. Bryan was a Democrat. And Walter White was there at Robinson's drugstore when this whole shindig was conceived. So Stewart asks Walter White, on behalf of the state, what books or subjects Scopes taught. They have to make their case, right? So Walter White says, well, Scopes was a science teacher. He taught chemistry, biology, and other subjects in the science course. I mean, this is almost surely not true, and everybody knows it. Now, Darrow did not want Scopes to take the stand because Darrow knew that Scopes was not a science teacher, certainly not a biology teacher, and he was afraid that if Scopes was asked under oath if he had actually taught biology, all right, that's a perjury trap to be avoided. And White says that Scopes taught from this book, Hunter's Biology. White says that Scopes had told him about teaching Hunter's Biology on the afternoon of May 4th. This is when they're sitting around Robinson's drugstore. And Stewart says, well, when Scopes admitted to this, that he had taught from this textbook, we think that's an admission of the facts necessary to make this case. And Clarence Darrow says on the record, it is. Right? Darrow wants to nail this point home because otherwise we have no trial, and he wants to do it without Scopes having to say so under oath, because that would be perjury. Now we get to some good stuff, and I want to do it in a little detail because it sets the stage for what comes on the next days of trial in our next lecture, the most famous piece of this trial. Attorney General Tom Stewart offers the King James Version of the Bible as an exhibit and says this is what the act related to, the Butler Act, when it said the Bible. Arthur Garfield Hayes is off and running, and he says, what is the Bible? Hayes then makes a long speech about how many different versions of the Bible there are. Various Protestant sects use the King James Version published in London in 1611. Catholics use another version, the Old Testament of which was published in 1609, the New Testament in 1582. Manuscripts written in Hebrew, Aramaic, and Greek have been lost for hundreds of years. And Hayes says, which version does the Tennessee legislature call for? Does it intend to distinguish between different religious sects in passing this law? They could be required to call some witness here to testify what the Bible is. Hayes goes on. There are differences of translation, many of which seem unimportant, though Catholics claim there are cases of willful perversion of the scriptures in King James translation. In other words, Your Honor, they should be required to designate the violation of the law. The court may take judicial notice of the Bible. Judicial notice is when the court says everybody knows X. The Berkshire Eagle is a paper of general circulation in the Berkshires. That's a fact a court could take judicial notice of. The court may take judicial notice of the Bible, but the court does not take judicial notice of a fact that is at issue between the parties. It can only take judicial notice of matters that are of common knowledge. It says, we object to this Bible going into evidence before they can prove what Bible the statute is talking about. The judge says, objection overruled. Darrow, undaunted, what parts of the Bible are you going to introduce? He says, we just want to know what particular edition it is. Whereupon Tom Stewart says, it's Holman's pronouncing edition of the Holy Bible, containing the Old and New Testaments, text conformable to that of 1611, known as the Authorized or King James Version. Does anybody here this morning happen to have with them the Holman's pronouncing edition of the Bible? Okay, I thought that might be the case. Don't worry, I do. This is what I believe to be a copy of what was introduced into evidence, and I say that because I trust that Amazon steered me in the direction I was heading. So I've taken a look at the publisher's preface. The Bible, strictly speaking, is not a book, but a library of brief writings, some of which contain histories, some codes of law, some prophecies, some collections of religious songs and proverbs, and some epistles. That doesn't sound like the kind of language that would comfort the prosecution in this case, right? Then the preface goes on. The proof that this collection of literature is the Word of God is that it possesses the qualities and powers that belong to such a word. It is true, and being true, it appeals to our sense of truth and approves itself to us. It was the approves itself to us that kind of lost me. Hayes continues his objection. There are umpteen versions of the Bible. Darrow says, where can we buy a copy of this published version of the Bible? And Tom Stewart says, where do you think? That's right, Robinson's drugstore, where you can buy everything else. Next, the prosecution calls as its next witness Howard Morgan. 14-year-old Howard Morgan is examined by Mr. Stewart on behalf of the prosecution. He gets him to say, yes, he studied with Mr. Scopes in the latter part of April after this law went into effect. And Howard Morgan then describes John Scopes' crime. Morgan says, he said that the earth was once a hot molten mass, too hot for plant or animal life to exist upon it. In the sea, the earth cooled off. There was a little germ of one cell organism formed, and then this organism kept evolving until it got to be a pretty good-sized animal, and then came on to be a land animal, and it kept evolving, and from this was man. How did Scopes classify man with reference to other animals? Howard Morgan, the book and he both classified man along with cats and dogs, cows, horses, monkeys, lions, horses, and all that. What did he say they were? Howard Morgan, mammals. Classified them along with dogs, cats, horses, monkeys, and cows? Yes, sir. That was it for the prosecution questioning a 14-year-old student, Howard Morgan, and of course, Scopes almost surely never taught him any such thing. Now Darrow gets to cross-examine Howard Morgan. This is classic Darrow, and it becomes a touching scene in Inherit the Wind in the movie. Now, Howard, what do you mean by classify? Well, it means classify these animals we mentioned, that men were just the same as them. In other words, Darrow, he didn't say a cat was the same as a man. No, sir. He said man had a reasoning power that these animals did not. Darrow, there's some doubt about that, but that's what he said, is it? Laughter in the courtroom. Darrow asks him, what makes something a mammal? Howard says he doesn't recall. Darrow asks, well, did he tell you anything else that was wicked? And the author, Ray Ginger, says that Mr. Mr. Morgan, 14 years old, shot a quick glance at Scopes and grinned, and the judge and the attorney general smiled. All right, there were more questions about what makes something a mammal and about this molten mass of liquid, et cetera, et cetera. Darrow finishes with, he says, all this stuff that he taught you, it hasn't hurt you any, has it? Howard Morgan says, no, sir. Darrow, that's all. Laughter in the courtroom. This is Darrow at his charming best. In the movie, this becomes, he grabs the young person's right arm and says, didn't hurt your pitching arm any, did it? And the kid says, no, I'm a southpaw. Brief questioning now of another student, Harry Shelton. Very brief by the prosecution. Darrow cross-examines even more briefly. After Harry Shelton says that Scopes taught him all about life coming from a single cell, Darrow asks him, are you a church member? Sir? Are you a church member? Yes, sir. Do you still belong? Yes, sir. You didn't leave the church when he told you all forms of life began with a single cell? No, sir. I love this line of questioning because for all the hoopla about how teaching evolution was going to hurt young people, the defense shows that it wasn't so with Scopes' students. And it reminds me of the contemporary arguments that we have when it comes to recognizing same-sex marriage. Is there any evidence that any marriage between people of different genders was harmed by allowing people of the same gender to marry? Anyway, author Ray Ginger says that after court adjourned, some reporter that day interviewed the mothers of these two students, and they were both supportive of their students learning about evolution. And Harry Shelton's mother said that when her son was asked to testify, he had to get his book out and bone up because he had forgotten the lesson. The prosecution now calls Doc Robinson of Robinson's Drugstore to get him to say what was discussed when Scopes came to the drugstore that day. And Robinson says that Scopes had said any teacher in the state who was teaching Hunter's biology was violating the law. Clarence Darrow now cross-examines. He gets Robinson to say that he sold Hunter's biology, the textbook. Question, and you were a member of the school board? Answer, yes, sir. Laughter in the courtroom. Darrow, I think somebody ought to advise you that you are not bound to answer these questions. Tom Stewart says, the law says teach, not sell. All right, more laughter in the courtroom. Darrow gets Robinson to say that he sold the book for 6 or 7 years. Darrow is clearly having a good time. Question to Robinson, have you noticed any mental or moral deterioration growing out of the thing? Tom Stewart, how is that? Darrow, have you noticed any mental or moral deterioration growing out of this thing? Stewart, exception, meaning objection. Judge, I sustain the exception. I think the judge isn't so easily amused by this. Darrow objects to the judge's ruling. He gets Robinson to say that he gets the books from the school depository in Chattanooga. They were adopted by the State Board of Education. Tom Stewart says, since Darrow has now read from the book, he read some excerpts from Hunter's biology, Stewart now wants to read the first 2 chapters of Genesis into the record, just in case the verses from Genesis changed from the day that the judge read them into the record at the beginning of the case. Okay, with this, the government, the prosecution rests its case, and Darrow says, let's keep going, let's start the defense case, and Darrow calls to the stand Dr. Maynard Metcalf. An interesting little procedural tidbit, Tom Stewart stands up and says, look, with all due respect, in Tennessee here, we have a rule that if you don't call the defendant as your first witness, he doesn't get to testify at all, right? So they're starting with an expert, and Darrow says, well, you got me on that. And the judge says, I'll let you withdraw this witness, but Darrow says, look, every single word that's been said about this defendant, everything was true. And the judge says, so he doesn't care to go on the stand? And Darrow says, no, what is the use, right? Darrow's keeping Scopes. Scopes' job is keep your mouth shut. Back to Dr. Metcalf. He's a zoologist with impeccable credentials. He was a professor of zoology at Oberlin, then at Johns Hopkins, the highest level professional affiliations. When he was asked his age, He said, 58. Wait, no, 57. I think that's right. It's like he's playing for the role of absent-minded professor. Darrow then gets to some serious business with Metcalf. Do you know any scientific person in the world that is not an evolutionist? Tom Stewart, objection. Judge, sustained. Arthur Garfield Hayes says, we need to rule on this. The judge says, a mere guess by a few men or generally accepted by all scientists, I don't think you can bring in one witness to prove what others believe. This could not be more wrong. This is a classic function of expert witnesses who come in and say, it is a generally accepted principle in the field of X, that. Because that's how you get that kind of information to a court, once you establish that the expert has the expertise to make that kind of statement. Hayes says, our whole case depends upon proving that evolution is a reasonable scientific theory. The judge says, I don't know how you can do it through this guy. He says, Hayes says, we expect to prove what all science says. And the judge says, well, bring them in here and offer them. I'll hear you. I mean, this is craziness. So there's more lawyer discussion about this issue. Darrow asks him, is there anything in the theory of evolution in conflict with the account of the creation of man in Genesis or in the Bible? Is evolution taught in all the leading colleges of the world? The witness goes on and on for several minutes about evolution and mammals and teaching all this. At one point, he speaks of life as having existed 600 million years ago. Author Ray Ginger says, when Metcalf said that, spectators laughed incredulously. People whispered in disbelief. The judge gasped and took a long drink of water. A voice said, he is about as authoritative as an evening breeze. That was the end of day 4 of the trial. Day 5, Thursday, July 16th. How does court begin? Opening prayer. Then Darrow asks Metcalf a few more questions about evolution, and there's argument with Tom Stewart. Darrow says, he says, here's what the evidence will show and what evolution is. And secondly, that any interpretation of the Bible that intelligent men could possibly make is not in conflict with any story of creation, while the Bible, in many ways, is in conflict with every known science, and there isn't a human being on earth who believes it literally. We expect to show that it isn't in conflict with the theory of evolution. We insist that a jury cannot decide this important question, which means the final battleground between science and religion, without knowing both what evolution is and the interpretation of the story of creation. Tom Stewart is having none of it. He says, the act says they shall not teach that man descended from a lower order of animals, and for these reasons the testimony would be incompetent. It does not have a place. Now we hear from another member of the state's team, William Jennings Bryan, Jr. This is son of William Jennings Bryan. He presents an argument about excluding these defense experts. John Scopes said in his own memoir, he got to know William Jennings Bryan, Jr. Says, one day, it's not clear what day of the trial, the two of them went swimming together. They temporarily forgot about the trial, and they were late returning to the courtroom that afternoon. So William Jennings Bryan, Jr. says, we've reached the heart of the case. John Neal interrupts to make a request of William Jennings Bryan, Jr. that I bet no one ever made of his father. Can you speak a little louder? Okay. The junior continues. The defense wants to put on an expert to say that in his opinion, evolution doesn't contradict the Bible. That's not a statement of fact, it's an opinion. And if a man gives a false opinion, there's no way you can contradict him. This is wrong in so many ways. That's what expert testimony is. It's the opinion of an expert. Judge Ralston, will you speak a little louder? Bryan Jr. continues. He says that Clarence Darrow had referred to an expert in the Leopold and Loeb trial as a purveyor of perjury. What's going on here? Remember, we talked a bit about Leopold and Loeb. It was just a year before, and the state's references to Darrow's involvement in that case are no accident. Remember Nathan Leopold, Dickie Loeb, two wealthy Chicago teenagers who murdered a 14-year-old kid solely for the purpose of fulfilling their fantasy of trying to execute the perfect crime. Clarence Darrow got them off, spared them the death penalty, and his speeches about the death penalty are classics. And in his summation in that case, Darrow leaned heavily on his view of a deterministic universe. He said, nature is strong and she is pitiless. She works in mysterious ways and we are her victims. We have not much to do with it ourselves. And he talked about the influence on Leopold of the writings of Nietzsche and the Superman theory. In the Leopold and Loeb case, the prosecution attacked Clarence Darrow's argument on many fronts, and the prosecutor referred to the defense psychiatrists as the three wise men from the East. It occurs to me, in the Leopold and Loeb case, which was in Chicago, Chicago was making fun of the East. Now at the Scopes case in Dayton, we've got Tennessee making fun of Chicago and New York. Anyway, Leopold and Loeb were spared the death penalty, but this was in people's minds 10 months later when Darrow argued in Dayton. The state referred to the Leopold and Loeb case about a dozen times during the trial, trying to link Darrow's arguments there about lack of free will to the evils of evolution. William Jennings Bryan Jr. finishes. There's a brief recess. The judge comes back and he says, "We have some lawyers in the case who at times indulge in a lot of wit. I don't know who's going to argue the case, and I don't know whether they're going to display their wit or not, but if they do, I don't want any manifestations in the courtroom for two reasons. The first reason is it's improper. The second reason is this floor of the courthouse building is heavily burdened with weight. I don't want to alarm you. I don't know myself, for I am not a mechanic, but I do know that the floor is heavily weighted, and the least vibration might cause something to happen, and applause might start trouble." Whereupon Arthur Garfield Hayes, not missing a trick, said, "Oh, if Your Honor, please, I am rather embarrassed by your illusion that there will be such thunderous applause for my remarks that the building might come down." Hayes says, first, the state objected to the jury hearing the law. Now they object to the jury hearing the facts. The state keeps trying to say what the defense case is. The state says that we admit that Scopes taught something that violated the law. We admit that he taught what the witnesses say he taught, but as to whether that's contrary to the Bible, that should be a matter of evidence, and no court would exclude expert testimony on matters of science. Hayes, with respect to the remark made by General Mackenzie the other day, one of the prosecutors, where he said that any Tennessee schoolboy of 16 should understand this law, I wish to say that if that is so, they forget it by the time they get to the age of Attorney General Stewart and do not again acquire it by the time they reach the charming age of General Mackenzie. What is evolution? Does the judge know? Does anyone know? Hayes goes on about this and he says, any boy of 16 without special study doesn't even understand the term lower order of animals, and neither does the prosecution. Their theory seemed to be that at the beginning that Professor Scopes taught and that evolution teaches that man has descended from a monkey. If Professor Scopes, right, remember, now he's a professor, the guy was the football coach. If Professor Scopes taught that, he would not be violating this law. Now, you will need evidence to prove that that is a fact, because the orders of animals were classified by Linnaeus about 200 years ago, and it was an artificial classification. In the first order, the primate order, was man, monkeys, apes, and lemurs. That's the first order. To prove that man was descended from a monkey would not prove that man was descended from a lower order of animals, because they're all in the same order of animals, the first order. Hayes continues, the textbook Scopes used was prescribed by the state. Can it be illegal to use the textbook prescribed by the state, but also illegal not to use it? Hayes says, what evolution is a fact question. It's not a matter of opinion. The court needs the scientists to explain it. Court takes a recess. Then Sue Hicks speaks for the state. There's some Q&A between Sue Hicks and the judge about what the state's theory is. He says, our theory is that Scopes taught it developed into the different animals and came from one animal to another, passed on up until it culminated into man. himself. Hicks, I would like to be given the right to challenge these men. They are without. They are outside the state of Tennessee. They come in to interpret our law of our legislature. What do they know about the Bible? They have to qualify in both the Bible and science before they can. Hayes says, we want you to hear them first before you decide, Judge. Darrow, after they testified, the motion by the state would be to strike their testimony. Stewart says, I expect we would get along better if there were less heckling. And all of a sudden, heckling is the word of the day. Sue Hicks, why should these experts know anything more about the Bible than some of the jurors? Remember, some of the jurors, the only book they'd ever read was the Bible. There's one on there on the jury I will match against any of the theologians they will bring down. He knows more of the Bible than all of them. Malone, Dudley Field Malone from the defense. How do you know? Sue Hicks, what's the interpretation of the Bible? Some of the experts whom they brought in here do not believe in God. The great majority, the leading ones of the experts, do not believe in God. They have different ideas. Dudley Field Malone says, if Your Honor, please, how do you know that until you get them on the stand? We object. Judge says, I sustain the objection. Oh, that's a good moment for the judge. Judge says you can't assume what they believe. Hicks goes on. I don't know about where these foreign gentlemen come from, but I say this in defense of the state, although I think it's unnecessary. The most ignorant man of Tennessee is a highly educated, polished gentleman compared to the most ignorant man in some of our northern states, because of the fact that the ignorant man of Tennessee is a man without an opportunity. But the men in our northern states, the northern man in some of our larger northern cities, have the opportunity without the brain. The transcript says, laughter. The judge says he'll hear from General Mackenzie. Darrow says, please rule on the question. Are these guys going to get to testify or not? They're sitting around. Judge says, it's highly probable the court will not pass on this question today. Darrow says, I think you ought to pass on it immediately, even if you pass on it wrong. Darrow figures he excludes them, at least they can go home. Now General Mackenzie speaks. And maybe he's trying to take some of the sting out of Hicks's comments about foreign gentlemen. Since the beginning of this lawsuit, and since I began to meet these distinguished gentlemen, I have begun to love them, every one. And it is a very easy task, in fact. It was the case when I met Colonel Darrow, a case of love at first sight. These other gentlemen come right on, but they wiggled around so rapidly that I could not get my love turned loose on them until I got a chance, but I love the great men. Quick sidebar, 7 months after this trial, General Mackenzie was arrested for violating the local liquor laws. Clarence Darrow offered to defend him. Mackenzie declined. Mackenzie on the left talking to Darrow on the right. All right, Mackenzie then gets to the merits, so-called, of the case. He says there's not a thing on the face of the earth that's ambiguous about this statute. Judge, is this your position, that the story of the divine creation is so clearly set forth in the Bible that no reasonable minds could differ as to the method of creation? Mackenzie, yes. Court, Judge, here's what I want to get at. The Act says it shall be, and follow this, the Act says it shall be unlawful to teach any theory that denies the divine story of the creation of man. That's one issue. Or teach, or instead thereof, and Malone interrupts, and he says, and is the word, not or, and to teach instead. So the court stands corrected and says, yes, and teach instead that man descended from a lower order of animals. So the judge goes on, in order to make a case, he asks Mackenzie, does the state have to prove that the defendant Scopes taught a theory denying divine creation and then go further and prove that he taught that man descended from a lower order of animals? Or do you claim that if you meet the second clause, that man has descended from a lower order of animals, if you meet the second clause, by implication of law, you have met the requirement of the first? And Mackenzie says, that's it exactly. Namely, all we have to do is teach that man descended from a lower order of animals, and then we're covered on having denied the story of the divine creation. Mackenzie goes on talking about the defense argument. Darrow interjects. he says to Mackenzie, let me ask a question. By the way, this business of lawyers asking each other questions, this is pure show business. This doesn't go on in a real trial. Let me ask a question. When the Bible said, in his own image, do you think that meant the physical man? Mackenzie, I'm taking the divine account. He is like unto me. Darrow won't let it go. Do you think it's so? Mackenzie, I say that, namely, God is created in man's image. Oh, I'm sorry, man is created in God's image. Mackenzie says, I say that, although I know it is awfully hard on our Maker to look like a lot of fellows who are profusely ugly to say he favored the master. Now, Mackenzie is on the ropes, and you know it because he resorts to that kind of attempt at humor. He's making fun of the profusely ugly. I thought we were all God's children, right? Darrow continues, so you think then that you do. Mackenzie says, you're all right. I don't mind your favoring him, but when one commits an act against the law, there ought to be some remedy for it. Darrow says, wait a minute, Colonel. Actually, Mackenzie was a general. You think the physical man is like God? Mackenzie, I do. I will give you my reason. Darrow, I think God knows better. You think men must believe that to believe the Bible, that the physical man as we see him looks like God? Mackenzie, yes, sir, and I will give you my reasons as soon as you want them. Darrow, undaunted. And when you see man, you see a picture of God? Mackenzie, like unto him and made in his image. And the reason why I believe that firmly is because the Bible teaches it. When Christ came to earth, and I believe in the virgin birth of Christ. John Neal, everybody wants to get into the act. He asks, do you think a teacher in the Tennessee schools if a teacher in the Tennessee schools failed to teach that man is physically like God, it would be violating the statute? Great question. Mackenzie, we will try that lawsuit when we get to it. Darrow comes back with another question, and it's like he's using this as a dress rehearsal for the big show to come. You spoke about it taking a good many thousand years to get man under our theory. You said that there was a first day, second day, third day, fourth day. Do you think they were literal days? Pause for a minute. Now, we know what's coming. Right? Darrow is going to cross-examine Brian on the Bible. There are going to be questions about how long a day was during creation. People who have studied the trial have different views about when Darrow came up with the idea of cross-examining Brian. Did he cook it up long in advance? Did he think it up a day or two before they actually called Brian? There's conflicting evidence about that. But if I were Darrow, and I already had in mind calling Brian as a Bible expert, I would not be dangling these questions publicly before calling Brian. It would be like giving Brian a heads up and an opportunity to prepare. Darrow, do you think they were literal days? Mackenzie, we didn't have any son until the fourth day. I believe the biblical account. When Christ was here, he was like other men, but he was in the image of God. That's why I believe he was in the image of man. There's more back and forth with Mackenzie. They take a break for lunch. The judge starts with a very earthly type of announcement by cautioning people again about the floor of the courtroom being burdened by great weight. Now, William Jennings Bryan speaks. He talks about excluding the defense science witnesses. It's very hard to capture Brian's talk. He went on for 12 pages of transcript. That's about 70 minutes of material. First, he talked about his favorite subject, himself. And he said, you know, I haven't talked till now. It's been Tennessee lawyers talking about Tennessee law, but now we're getting to an important issue. He says that the other side says, I'm responsible for the presence of this case, and I've almost been credited with leadership of the ignorance and bigotry which he thinks could alone inspire a law like this. Mr. Hayes says that before he got here, he read that I, Brian, said this was to be a duel to the death between science and revealed religion. I don't know who the other duelist was, but I was representing one of them, and because of that, they went to the trouble and the expense of several $1,000s to bring their witnesses. Well, my friend, if you said that this was important enough to be regarded as a duel between two great ideas or groups, I certainly will be given credit for foreseeing what I could not then know, and that question is so important between religion and irreligion that even the invoking of the divine blessing upon it might seem partisan and partial. Then he starts talking about the statute. He says, what's the big deal here? He says, my friends, if the people of Tennessee were to go into a state like New York, the one from which this impulse comes to resist this law, the ACLU sitting in New York, or go into any state. If they went into any state and tried to convince the people that a law they had passed ought not to be enforced just because the people who went there didn't think it ought to have been passed, don't you think it would be resented as an impertinence? Pause for a second. He's in a courtroom. What's all this talk about my friends, right? It's like he's in a Chautauqua tent, and there's a reference to that in the movie. Brian continues, it isn't proper to bring experts in here to try to defeat the purpose of the people of the state by trying to show that this thing that they denounce and outlaw is a beautiful thing that everybody ought to believe in. Brian, what about the fact that the textbook was selected by the Board of Education and sold by Robinson's drugstore? Brian says, no matter what the Board of Education has done, no matter whether they put their stamp of approval on this book or not, the moment that law became a law, anything in these books contrary to that law was prohibited, and nobody knew it better than Mr. Scopes himself. It doesn't matter anything about who ordered these books. The law supersedes all boards of education, for the legislature is the Supreme Court on this subject from which there is no appeal. That's gibberish. Right? Of course, that's gibberish. There's no such thing as a law passed by a legislature from which there is no appeal. We've recognized that principle since Marbury versus Madison. This is a show business speech. This is not serious legal argument. William Jennings Bryan goes back to 14-year-old Howard Morgan. Howard understood evolution better than the lawyer who questioned him. The National Education Association doesn't understand evolution. There were so many different kinds of evolution, or so many definitions of evolution, that if they made a general statement, it would be useless. And if they went into detail, it would excite controversy. The transcript says laughter in the courtroom. I'm not sure where the laugh line was there. After poking fun at that gentleman from New York, I think that's Arthur Garfield Hayes, Bryan says, that's evolution, that's what he taught. Bryan refers back to the discussion of Linnaeus and the classification of man among the primates. He tries to quote Arthur Garfield Hayes, who then corrects Bryan and says, no, the term order of animals is a scientific term, and monkey and man were in the same order, but a different class. Bryan then asks Hayes, then are there ranks in an order, or all one rank? Hayes, no, there are various ranks in the order. They should have used your words, should have used the words class or families. Bryan doesn't want to deal with this. He shrugs it off and says, no matter what you said, it wouldn't make much difference because the answer would be just the same. More laughter in the courtroom. Bryan tries to wangle his way around this. If man and monkey were in the same class, called primates, it would mean that they did not come up from the same order. It might mean that instead of one being the ancestor of the other, they were all cousins. But it's beginning to sound like a country music song. But it does not mean that they did not come up from the lower animals if this is the only place they would come from. And the Christian believes man came from above, but the evolutionist believes he must have come from below. Laughter in the courtroom, and author Ray Ginger says, Bryan mistakenly thought the loud laughter was all with him. Bryan then goes through a diagram from Hunter's biology. Pause. Who was this guy Hunter, the author of Hunter's Civic Biology? Born 1873 in Mamaroneck, New York, Westchester County, New York. Got his undergraduate and master's degree from Williams College. Taught for 20 years at DeWitt Clinton High School in the Bronx. He dedicated his textbook to his fellow teachers of the biology department there. He published his textbook in 1914 while he taught at DeWitt Clinton. 5 years later, got his PhD from NYU. He wrote 4 biology textbooks. He taught at Carleton College, then at the Claremont Colleges in New York. He died in 1948. You could ask, who was Bryan to try to tackle Dr. Hunter? Let me quickly add, the enlightened Dr. Hunter's text advocates for eugenics and segregation. Remember, Bryan was opposed to eugenics, and most of what I've read suggests that his opposition to teaching of evolution was very much, in his mind, linked to opposing eugenics. in contrast to, I think I mentioned last week, the journalist H.L. Mencken, who was virtually the spokesperson for the defense team, who was an advocate of eugenics. Hard to square all of the issues and all of the people on one side of the line or another. So the version of the textbook of Hunter's Civic Biology that I have managed to obtain has an extensive section on Darwin and his contributions to biology. I am reliably informed, namely by looking at Wikipedia, that the year after the Scopes trial, a new edition was published omitting references to evolution and Darwin. Back to the trial. Brian is ridiculing the textbook. This diagram appears in the textbook. Let me just say quickly, because I'm no technology genius, it took me forever to figure out how to get it from the textbook onto a PowerPoint, onto here. And I knew I had screwed up because now when I turn on my computer, this is my screensaver. So Brian is going through the diagram. This is ridiculous. 518,000 animal species, 8,000 protozoa, 360,000 insects. He goes through it all. And Brian says, they were teaching your children that man was a mammal and so indistinguishable among the mammals that they leave him here with 3,499 other mammals. Laughter and applause in the courtroom. Tell me that the parents of this day have not any right to declare that children are not to be taught this doctrine, shall not be taken down from the high plane upon which God put man, on and on. Why, up in the state of New York, they're now trying to keep the schools from adjourning for 1 hour in the afternoon so that the children may go to the churches to which they belong and there have instruction in the work. And they're refusing to let the school do that. Brian starts reading from Darwin's The Descent of Man. Malone comments, it hasn't been offered into evidence. Brian inexplicably says, he'd be glad to offer it into evidence. Malone says, I agree. Laughter in the courtroom. Brian says, let's put it in. Malone, well, if you'll let us put our witnesses on to show what the works are. Brian says, not with that condition. Right? Now Brian is quoting Darwin at some length, and he's talking about one group of monkeys branching off into two stems, the New World and the Old World monkeys, and from the latter, man proceeded. So says Hunter's Biology. Brian can't resist. Not even from American monkeys, but from the Old World monkeys we descended. Laughter. It's another line that made it into Inherit the Wind. The judge asks Brian if evolution theory involved Christ's virgin birth. Brian says he's willing to answer that, and he says evolution's not a theory, just a hypothesis. That's fascinating, because some of you may understand that in the world of science and biology, to call something a theory, in common parlance, we say, oh, it's a theory, it's a guess. It ain't a guess. The gravity is a theory, right? And evolution is a theory, and maybe Brian was trying to recognize that and say, oh, it's not a theory, evolution, it's a hypothesis. Brian goes on at length about how evolution does indeed dispute the virgin birth. Right? He goes on, and he invokes Leopold and Loeb and Nietzsche, and he says, you know, we have the doctrine that and the universities that had taught it and the professors who taught it are much more responsible for the crime that Leopold committed than Leopold himself. He's taking Clarence Darrow's argument and twisting it to be that. And one gets the feeling that there's something bigger than evolution going on here. I think it's about fear. I think it's a fear that a worldview is about to be engulfed in something called modernity. It's a fear that a set of values is being threatened. Darrow can't let it pass. Your Honor, I want to object. There's not a word of truth in what Brian said. Nietzsche never taught what Brian said. And he said, he says there was no word of protest in any of the theological colleges when a clergyman in southern Illinois killed his wife to marry someone else. Brian can't resist the bait. We do not ask to have taught in the schools any doctrine that teaches a clergyman killed his wife. Judge Ralston inexplicably says, well, of course, I cannot pass on that question. These guys are going at it pretty tough, and incredibly, within a few brief seconds, they're joshing back and forth with each other. Brian started to read from Darrow's argument that the Leopold and Loeb trial, joking that the text had cost him $2. He says, anybody can get it for 50 cents a piece, but cannot buy mine. These are valuable. And Malone says, I'll pay $1.50 for it. Transcript says there's laughter in the courtroom. Bryan is quoting from Darrow's argument. Darrow thinks he's being misquoted. Let me see what you're reading from. Bryan says, well, okay, but let me have it back. And Darrow says, oh, I'll give you a new one autographed for you. Darrow then objects to the judge about these references to Leopold and Loeb. Judge Ralston says, it doesn't prejudice me. And Darrow says, well, then it doesn't do any good. And the transcript says, loud laughter and great applause. There's now back and forth between Bryan and Malone about who the defense intends to call. Bryan wants to get in his objection to the defense putting on Bible experts. When it comes to Bible experts, do they think they can bring them in here to instruct the members of the jury, 11 of whom are members of the church? I submit that the 11 members of the jury, more of the jurors, are experts on what the Bible is than any Bible expert who does not subscribe to the true spiritual influences or spiritual discernments of what our Bible says. Voice in the audience, amen. Bryan continues. And the man may discuss the Bible all he wants to, but he does not find out anything about the Bible until he accepts God and the Christ of whom he tells. Darrow says, I hope the reporters got the amens in the record. Another line that shows up in the movie. Bryan goes on for another 5 to 7 minutes about how we don't need science. Then he was done. The author, Ray Ginger, says that the applause for Bryan was disappointing. It was polite. Darrow then read from what he had actually said at the Leopold and Loeb case. I want to share it with you. I do not believe that the universities are to blame. I do not think they should be held responsible. You cannot destroy thought because some brain may be deranged by thought. It's the duty of the university, as I conceive it, to be the great storehouse of the wisdom of the ages and to let students go there and learn and choose. I have no doubt but that it has meant the death of many. That we cannot help. Every changed idea in the world has had its consequences. Every new religious doctrine has created victims. Every new philosophy has caused suffering and death. Every new machine has carved up men while it served the world. No railroad can be built without the destruction of human life. No great building can be erected but that unfortunate workmen fall to the earth and die. No great movement that does not bear its toll of life and death. No great idea but does good and harm. And we cannot stop because it may do harm. In connection with Nietzsche, he wasn't connected with the university at all. He was a disciple of the doctrine of Superman. Darrow says Nietzsche didn't make half as many insane people as Jonathan Edwards, your great theologian, and he did not preach the doctrine of evolution. He said that Darwin had a great mind, and I suppose Colonel Bryan would say that. And with that, Judge Ralston said he'd heard enough, and he turned the floor over to Dudley Field Malone. That Darrow riff about every good idea, new idea brings good and bad is, I believe, mimicked in the Inherit the Wind movie when Darrow talks about you can enjoy the grandeur of flight, but the clouds will smell of gasoline. Dudley Field Malone then replied to Bryan. Sorry, lost a few there. Dudley Field Malone's reply is probably the single most underappreciated moment of the trial. It got overshadowed by the still-to-come head-to-head combat between Darrow and Bryan. Malone's reply was referred to as his duel with the truth speech. John Scopes himself later called it the most dramatic event I have ever attended in my life. Malone's reply is worth extended discussion because of its eloquence and its drama and the way he distilled the issues. It looks like he spoke for about 30 to 40 minutes. I'll slice it down. He began by needling Bryan with a joke. Probably this is the time to discuss everything that bears on the issues that have been raised in this case, because after all, whether Mr. Bryan knows it or not, he is a mammal, he is an animal, and he is a man. Regarding disagreement about the meaning of text, Malone said, if we depended on the agreement of theologians, we would all be infidels. I think it is poor taste for the leader of the prosecution to cast reflection or aspersions upon the men and women of the teaching profession in this country. They had taken their shots at teachers. Mr. Bryan quoted Mr. Darwin. That theory has evolved. The theory was evolved and explained by Darwin 75 years ago. Have we learned nothing in 75 years? Here we have learned the truth of biology. We have learned the truth of anthropology. And we have learned more of sociology. Are we to hold mankind to a literal understanding of the claim that the world is 6,000 years old because of the limited vision of men who believed the earth was flat, that the earth was the center of the universe, and that man is the center of the earth? Have we learned anything in 75 years? Are we to have our children know nothing about science except what the church says they shall know? Malone says, Mr. Bryan may be satisfactory to thousands of people. It is in so many ways that he is satisfactory to me. His enthusiasm, his vigor, his fighting ability these long years for the things he thought were right. And many a time I have fought with him and for him. And when I did not think he was right, I fought just as hard against him. This is not a conflict of personages, it is a conflict of ideas, and I think this case has been developed by men of two frames of mind. We're told that Malone then looked at Bryan when Malone said, "We have been told here this was not a religious question. I defy anybody after Mr. Bryan's speech to believe that this was not a religious question." Mr. Bryan brought all of the foreigners into this case. Mr. Bryan had offered his services from Miami, Florida. He does not belong in Tennessee. If it be wrong for American citizens from other parts of this country to come to Tennessee to discuss issues which we believe, then Mr. Bryan has no right here either. But it was only when Mr. Darrow and I had heard that Mr. Bryan had offered his name and his reputation to the prosecution of this young teacher that we said, well, we will offer our services to the defense. Malone then spoke to the issue. Says the prosecution has to show that Scopes not only taught a theory that man had descended from a lower order of animal life, but at the same time, instead of that theory, they must teach the theory which denies the story of divine creation set forth in the Bible. We maintain we have a right to introduce evidence by these witnesses that the theory of the defendant is not in conflict with the theory of creation in the Bible. Then back to his favorite topic, Mr. Bryan. Probably no man has done more to establish certain standards of conduct in the mechanics and world of politics than Mr. Bryan. But is that any reason I should fall down when Bryan speaks of theology? Is he the last word on the subject of theology? These gentlemen say the Bible contains the truth. If the world of science can produce any truth or facts not in the Bible as we understand it, then destroy science but keep our Bible. And we say, keep your Bible. Keep it as your consolation, keep it as your guide, but keep it where it belongs. In the world of your own conscience, in the world of your individual judgment, in the world of Protestant conscience that I heard so much about when I was a boy. Keep your Bible in the world of theology where it belongs, and do not try to tell an intelligent world and the intelligence of this country that these books written by men who knew none of the fundamental facts of science can be put into a course of science, because what are they doing here? The law says what? It says that no theory of creation can be taught in a course of science except one which conforms with the theory of divine creation as set forth in the Bible. In other words, it says that only the Bible shall be taken as an author on the subject of evolution in a course of biology. The judge then asks, is it not within the province of this court to determine which is true? Malone, no, but it's within the province of the court to listen to the evidence we wish to submit. Judge, is it your opinion that the theory of evolution is reconcilable with the story of the divine creation as taught in the Bible? Malone, yes. Judge, when the Bible says that God created man, you believe that God created the life cells and that then out of that one single life cell, God created man by a process of growth or development? Is that your theory? Malone, yes. You get the impression the judge is actually trying to understand something here, right? Malone then asks, why is the prosecution trying to narrow the case? What is the issue that has gained the attention not only of the American people, but people everywhere? Is it a mere technical question as to whether Scopes taught the paragraph in the book of science? No. The issue is as broad as Mr. Bryan himself has made it. If the issue is as broad as they make it, why the fear of meeting the issue? I believe that if they withdraw their objection and hear the evidence of our experts, their minds would not only be improved, but their souls would be purified. Really? think he got a little carried away there. Malone goes on, are the teachers and scientists of this country in a combination to destroy the morals of the children to whom they've dedicated their lives? Are preachers the only ones in America who care about our youth? Is the church the only source of morality in this country? Malone was beginning to wind up. The author Ray Ginger says that Malone had seized on Bryan's flatulent rhetoric to imply that Bryan was no Christian. Bryan had called the trial a duel to the death. So Malone said, we have come in here for this duel. I don't know anything about dueling, Your Honor. It is against the law of God. It is against the church. It is against the law of Tennessee. But does the opposition mean by duel that our defendant shall be strapped to a board and that they alone shall carry the sword? Is our weapon to be taken from us so the duel will be entirely one-sided? That isn't my idea of a duel. Then Malone gets to his real point. There is never a duel with the truth. The truth always wins, and we are not afraid of it. The truth is no coward. The truth does not need the law. The truth does not need the forces of government. The truth does not need Mr. Bryan. The truth is imperishable, eternal, and immortal, needs no human agency to support it. We are ready to tell the truth as we understand it. We do not fear all the truth they can present as facts. We are ready. We feel we stand with progress. We feel we stand with science. We feel we stand with intelligence. We feel we stand with fundamental freedom in America. We are not afraid. Where is the fear? We meet it. Where is the fear? We defy it. We ask Your Honor to admit the evidence as a matter of correct law, as a matter of sound procedure, and as a matter of justice to the defense in this case. Whew. The transcript says, profound and continued applause, the bailiff raps for order. The author Ray Ginger says the clapping was louder than it had been after Bryan's speech. A bailiff, he's an interesting little story himself, and a bailiff was pounding on the table with a policeman's club. The Chattanooga chief of police asked him why he didn't applaud. The bailiff replied excitedly, what did you think I was doing, rapping for order? Scores of people gathered around Malone to congratulate him. H.L. Mencken was coming down the aisle. Ray Ginger says, Malone eagerly awaited Mencken's praise. Mencken, in his inimitable fashion, says, Dudley, that was the loudest speech I ever heard. Mencken later wrote that the response was so enthusiastic that Darrow turned to Mencken and said, good God, that scoundrel will hang the jury, right? He was so good, somebody on the jury might buy it. A hung jury, meaning the jury can't reach a unanimous conclusion, that would ruin the whole thing. What they needed was a result, and really what they wanted was a conviction. Attorney Tom Stewart then spoke for the prosecution. He started with the usual, I don't believe I came from the same cell with the monkey and the ass, and it went downhill from there. He started talking about the intent of the legislature, and he says everybody knew what the legislature intended here, that the legislature meant that the doctrine that man descended from the lower order of animals contradicted the biblical account of creation, and therefore no scientific testimony is irrelevant. Stewart, under a correct construction of the act, if the court please, when this teacher teaches to the children of high schools of Ray County that they are descended from a lower order of animals, he has done all that is necessary to violate this act. He has at the same time taught a theory that denies the divine story of creation. Why? Because the act says so. Stewart goes on, and then the judge asks, you say when you meet the requirements of the second clause and prove that it's violated, that by necessity, by implication of law, that meets the first section? And Stewart says, yes. Hayes is now chomping at the bit and gets the judge's permission to ask Stewart. Hayes says, you construe the statute, and by the way, this is legal argument stuff here, it's the real thing. You construe the statute to be just the same as if the first part were out. The first part, to teach the story that denies the story of the divine creation. You construe it to be the same as if the first part were out, and that it's only the second part that you have to prove. So the statute would be the same if the first part didn't even exist. Am I right on that? Hayes says, you agree with me, don't you, that every word or phrase in the statute should be given some meaning? This is a cardinal principle of what lawyers call statutory construction. You must be able to give meaning to all the words in the statute. You must be able to figure out how to harmonize them, how to reconcile them. And Tom Stewart says, no, sir. I don't agree that every word in the statute has to be given meaning. The court has a right to leave out the words that do not express the intention of the legislature. Stewart says, this is a battle between religion and God. Darrow's an agnostic, blah, blah, blah. Stewart goes on. He cites the Puritans. He cites George Washington. Stewart says, we are told that the great general of the Southern Confederacy, Robert E. Lee, prayed to God before each battle, and yet here we have a test by science that challenges the right to open the court with a prayer to God. As I was reading this, I felt like going back in time to say to Tom Stewart, you know, we don't really cite Robert E. Lee for a lot of moral stuff anymore. And, you know, here in Massachusetts, particularly here in the Berkshires, we're more inclined to go with, say, Du Bois, Mumbet, right? Stewart, I say scientific investigation is nothing but a theory and will never be anything but a theory. Show us some reasonable cause to believe it is not, they cannot do it. Arthur Garfield Hayes, give us a chance. Stewart, a chance to what? Hayes, to prove it, to show you what it is. Stewart, that charge strikes at the very vitals of civilization and of Christianity and is not entitled to a chance. Applause and laughter throughout the House. You're not entitled to a chance to prove by the word or mouth of man that man originated in the bottom of the sea. It is as absurd and ridiculous as to say that man might be half monkey, half man. That was the end of day 5. On day 5 of the trial, George Rapelier, remember him? Okay, this was all his idea. George Rapelier was arrested for speeding for the 3rd time since the trial started. Rapelier said he was being persecuted. He said he was the most careful driver in Ray County. Arthur Garfield Hayes offered to represent him. Don't you love that image? One of the country's leading trial lawyers offering to defend a speeding ticket. The city commissioners heard about this and told the presiding official, put off Rapelier's hearing for 10 days until this gang is gone. Rapelier protested and demanded his hearing no later than Friday afternoon. The presiding officer said, too busy. And it was evening and it was morning of the 6th day. The court began on Friday, July 17th, the 6th day, with the bailiff asking, it's in the transcript, is Reverend Mark in the house? Reverend Rabbi Mark. You don't often hear those words put together like that. Well, Reverend Rabbi Mark was not there, about which more later. So the bailiff called another reverend who delivered a prayer. Now we get to the business at hand. The judge is going to read his ruling on the motion to exclude the defense science experts. The judge said the defendant's theory was that the prosecution had to prove both that Scopes taught evolution and that it was contrary to the Bible, right? Both clauses of the statute. The judge rejected that approach. He said, did the legislature mean that conviction required 2 things, teach this, denying divine creation, and that man descended? If both are required, then we have to have proof of what the story of divine creation is and proof about what the theory was taught denying that. But if the second clause merely explains the first, then we only need to know that the theory as taught denied the Bible. Judge says what the legislature intended, the second clause is good enough. Plainly wrong as a matter of law. Arthur Garfield Hayes objected and talked about you need the evidence to understand what we're talking about. The objection was entered on the record. He says, Hayes had said to try to determine whether this law is unreasonable without, for the court, to try to determine whether this law is unreasonable without informing itself by evidence, assumes plenary knowledge on a subject which has been the subject of study of scientists for generations. Okay, so the objection's on the record. Tom Stewart says he objects to the manner in which Hayes made his objection. I think it is a reflection on the court. Judge says, well, it don't hurt this court. Stewart, I think there's no danger of it hurting the court for that matter. Darrow said, there's no danger of it hurting us. Stewart, no, you are already hurt as much as you can be hurt. Darrow, don't worry about us. The state of Tennessee don't rule the world yet. Ouch. Now there's discussion about between the lawyers and the judge about how to proceed. We have these science experts. Should they take the stand and say what they would say? Should they submit written affidavits? There's a whole long back and forth about that. At one point in the back and forth, the judge says to Darrow, always expect this court to rule correctly. And Darrow says, no, sir, we do not. Laughter. Darrow then asked for the rest of the day to draft witness statements, put in affidavits to say what the various science experts would have said. It's not an unreasonable request. He said, look, the court had taken a half day to write an opinion, and the judge started to express reluctance about giving Darrow this time. Darrow says, I don't understand why every request of the state and every suggestion of the prosecution should meet with an endless waste of time, and a bare suggestion of anything that's perfectly competent on our part should be immediately overruled. The judge, I hope you do not mean to reflect upon the court. Darrow, well, your honor has the right to hope. Judge, I have the right to do something else, perhaps. Darrow says, all right. Remember that exchange. You haven't heard the last of it. The judge punts the question about introducing the science testimony and how to present what the science experts would have said. He punts that to Monday morning. So it's Friday, it's 10:30, and court is adjourned so the defense has the rest of the day to prepare the written statements. At this point, the judge asks Malone if he and Darrow and Hayes would pose for a picture with William Jennings Bryan and the judge. Malone says, I think it would be more satisfactory all around if Your Honor were photographed with counsel for the prosecution alone. Ray Ginger reports that the concessionaires in town were unhappy with the judge's ruling of no expert testimony from the bench. Why? Shorter trial means fewer sales, fewer hotel rooms, fewer hot dogs to sell. H.L. Mencken said, at this point, there was nothing left to do in the trial except, quote, the formal business of bumping off the defendant. On Saturday, H.L. Mencken left Dayton and left the trial. What about the exchange between Darrow and the judge on Friday? I hope you don't mean to reflect on the court. Well, Your Honor has the right to hope. Was the judge going to hold Darrow in contempt of court? There was a rumor that the Chattanooga Bar Association had a plan to try to disbar Darrow from practicing in Tennessee. So what happened over the weekend? That Friday night, remember, is Reverend Rabbi Mark in the courtroom? Well, Rabbi Mark had planned to speak that Friday night back at his congregation in Knoxville on impressions of the Scopes trial. He was met at the temple by a committee of congregants who had strong objections. After the meeting, Rabbi Mark appeared late before the congregation, said he had decided to postpone his talk until after Sunday, when the synagogue membership would vote on whether they wanted to hear it. I have found no evidence about whether Rabbi Mark ever delivered that talk. What happened over the weekend? A New York Times reporter still in Dayton reported what the author Ray Ginger has called a lesser conspiracy, that the defense may call to the stand William Jennings Bryan. When did this idea first materialize? Arthur Garfield Hayes wrote that it was unpremeditated. But 2 years earlier, in July 1923, Darrow had published in the Chicago Tribune his list of 55 questions about Genesis that he begged William Jennings Bryan to answer. One of the authors I've quoted earlier in the lectures, L. Sprague de Camp, recounted that after court on Thursday, right, the day before, Darrow said to Reverend Potter, our Unitarian minister friend, Darrow told Potter that he intended to put the greatest Bible expert in the world on the stand, William Jennings Bryan. He told Potter, keep it to yourself, but that Darrow was going to need Potter's help. So on Sunday night, July 19th, Darrow met with a Curtly Mather, the chairman of the geology department at Harvard and an ardent Baptist. Now, Mather had said to Darrow he was concerned about the effect of the trial on religion, that people would be misled into thinking they had to choose between religion and science. Well, Darrow and Hayes sat down with Mather. They told him, you be William Jennings Bryan and answer these questions the way you, Mather, think Bryan would. Ray Ginger says that for 2 hours they had a hilarious time. Mather asked how they intended to get Bryan to take the stand. They responded, we have our ways. How did they get Bryan on the stand? What happened when they did? It's almost 94 years later, and people are still talking about it. That's what we'll do next week. Any questions, comments, anything? Yeah.
I wonder who paid the expenses for the out-of-town witnesses, such as the zoologist, Dr. Metcalf?
Yeah, you know, I've seen a reference to it. I don't recall it off the top of my head. I know that I believe it was the ACLU, and there was an accounting of they spent several thousands of dollars to do this. What I'm very clear about is Darrow not only charged no fee, but paid all of his own expenses to participate.
Did I miss something? But why did Darrow arrange for these questions 2 years in advance of this trial?
Well, the question is, why, for the benefit of our video, let me just circle back. The first question was about paying for the expenses of the various experts who had come to Dayton, and it was the ACLU who fronted those expenses, and Darrow paid his own expenses and took no fee. On the question of why did Darrow, 2 years in advance of the trial? Why did Darrow in 1923, I think it was, why was he publishing a list of questions that he wanted Bryan to respond to about Genesis? And the answer is, these guys knew each other. Bryan had become a prominent face of the anti-evolution movement. Darrow saw it coming, and wanted to engage him in the debate. So this was a public way of doing it. Bryan, I believe, responded, I'll answer his questions when he answers mine. So there wasn't any formal response. But at that point, Bryan was writing about the evils of evolution. So the debate was being joined publicly. And that's why, regardless of whether the idea of bringing him to the stand in this case, whether it materialized on Thursday night or Friday, it wasn't entirely out of left field because, for the very reason that when Bryan said he was going to be involved, Darrow took that as the bait he couldn't resist and volunteered his services. Yes?
At the time of the trial, or in this whole debate of evolution versus Genesis, did anyone ever put forward the argument that Genesis talks about things happening in stages and water before land and simple to complex, and things that are sort of themes of how we see evolution? God created heaven and earth, and evolution is how we did it. Was that idea of reconciling them ever presented, or was it always there's one absolute answer versus another absolute answer and they don't match?
Yeah, the question is, did anybody try to articulate the argument that the biblical account calls for things happening in some stages anyway, and that that's not really antithetical to evolution? And the answer is, I think yes, that at different times there were certainly people, and I mentioned briefly, I think in the first lecture, that in the 1860s and thereabouts, scientists had no trouble saying that science and the biblical account are reconcilable with each other. I mean, there's then language about, this is all an act of, all of the biblical accounts can be scientifically proven. I don't know how one gets to that, but it really wasn't until the fundamentalists of the late 19-teens and in early 1920s, took offense at what they thought were the inferences of the teaching of evolution, that this issue became more joined. But keep that question in mind when we get to what Brian actually said when cross-examined by Darrow about various elements of the biblical account. I don't want to step on my own lines here, so let me just leave you with that for today, because what he said was a lot more nuanced than how we think we understand it from Inherit the Wind. And with that, per my promise, it's 11 o'clock, we're done, court is adjourned, see you next Tuesday. Thanks, everybody.
At OLLI, the Osher Lifelong Learning Institute at Berkshire Community College, enjoy learning simply for the love of it. Educational partners Williams College, BCC, Bard College at Simon's Rock, and MCLA provide some of our outstanding faculty. Take a class in the arts, history, literature, and so much more. Contact OLLI today. Meet new friends. Keep your curiosity alive.